I've had so many friends and colleagues over the years talk to me about scenarios where competitors of theirs have taken some of their clients, or perhaps somebody's come to work within their company and they've stolen all of their clients when they've gone to set up their own businesses and things like that. It happens quite a lot. And it's frustrating, I appreciate that, but there's also things that you can do from a contractual perspective which can protect you in those sort of situations. So if you are one of those businesses that does contract work out to subcontractors, so you might get specialists in to help you do certain services or whatever that might be, you certainly can include within the contract for that subcontractor clauses which can protect you. And in this podcast today, we're going to be talking about that. It's certainly relevant. We know it's relevant because these conversations pop up in the community quite a lot. And I've got a lawyer back on the show, a contracts lawyer, Helen Kay, to come back on the show and talk specifically about this topic. So something she's had a lot of experience with in the past, and obviously something that I know a lot of you guys, a lot of you listeners and viewers out there have either learned through the school of hard knocks or have had friends or colleagues that have had situations like this happen to them. Guys, enjoy the show. I'm sure you will. And if you've got any comments, by all means, just hit us up in the Facebook community. Helen's part of that group as well, so you can ask her directly in there. Cheers, guys. Enjoy. Today's podcast has been proudly brought to you by Tradie Web Guys. Tradie Web Guys work with tradespeople only on their websites and marketing solutions to help them stand out from their competition. Everything from web design through to SEO, search engine marketing, content creation, you name it, guys. It is a customized solution for trade-based organizations, and it's fantastic. Head across to tradiewebguys.com.au/apply, fill in the form, and let's have a conversation.
Giving tradies and contractors around the globe the tools to run a modern business. You're listening to Toolbox Talks from the Site Shed. Now here's your host, Matt Jones.
Helen Kay, welcome back to the Site Shed podcast.
Thank you for having me.
Now, there's a lot of listeners and viewers out there that are going to relate and resonate to what we're talking about today. We're talking about how to stop your competitors from stealing your clients. This has happened on numerous occasions to friends and colleagues of mine from the trades. I know one of my good mates, Brad, he had his one of another mate of ours just walk on the site one day and introduce himself to the builder, and as a result, I think he ended up undercutting Brad, and Brad lost all of the jobs from this guy from there on. It happens quite a lot. I think a lot of the guys are out there thinking, from a marketer's point of view, we see a lot of the people that we talk to have apprehensions around educating and giving away like valuable IP because they feel like for that reason, they feel like they need to hang on to it because it's what separates them from their customers and that kind of thing. Whereas in our experience today, it's kind of couldn't be further from the truth. Like we sort of feel that we sort of see that people that are willing to, give information away, like podcasts, for example. Who knows? There could be other lawyers out there that might listen to this and be taking notes on things they can do to take your ideas. But at the end of the day, like I feel like it kind of separates you. Like if somebody, and we get it all the time, like all of our web forms. I go through and check people that are subscribed to our database, and so many of them are like web design companies, marketers, and things like this. So people wanting to steal our stuff, steal our funnels, and steal all these things. And I just think it's kind of a a good position to be in when other companies want to come to you to steal your stuff to be as good as you are.
Isn't it the biggest compliment though, hey?
It is. I always laugh about it. I always, like, the devil on my shoulder is always there saying, oh man, just screenshot it and post it in the community. Just stick it on Facebook. I've done it in the past and I thought, it's interesting to know that there are, I suppose, legal ways that we can protect our customers. So protect our customers from our competitors. And that is something that I absolutely have no experience with. I wouldn't know what, things we can put in place there to do that, but it's pretty prevalent for sure.
Yeah, absolutely. And nothing more heartbreaking, hey, than somebody who's put blood, sweat and tears into a business and really got it good and got a good name for themselves, only to find the leads that good name generates have been funneling elsewhere. And a lot of the time it can take years before they figured it out.
So they're marketing for leads and the leads are going elsewhere. How would that happen?
Oh, so I'm talking about, so that example would be, so let's say somebody's using a similar name in social media.
Oh.
So you've, Matt Jones Plumbing is, taking the world by storm.
Yeah.
And so, you hadn't got around yet to setting up a appropriate Facebook group and Instagram. So somebody else who's a plumber has set that up under Matt Jones Plumbing. And, they're getting the inquiries, they're going out to see the client, they're doing the bookings, and all because you developed a really good name for yourself in the industry, but hadn't protected it properly.
And this is one of the things that we see. One of the first presentations I ever did, I had a section in it which I called Claiming Your Real Estate. And it was essentially about making sure, and mind you, this is going back probably, 8 years or so, where it was probably even less relevant than it is today. But, if you're starting out in business, or even if you're in business and you haven't yet gone through and claimed things like your social media channels, or if you are starting out in business, it's a really good exercise before you go and, I suppose, commit to a name, is you go and do your research and see what's available from a collateral perspective. So, what social handles are collateral? Is it available, or is it already taken? I know we've got a client in Sydney actually who, I won't say their name, but they essentially do like home maintenance, and they set up a business which was a .com.au, and they realised that there was a company in the UK which had the same name as a .com. And they ended up in a legal battle about the name, even though they were .com.au and they were a registered business here in Australia. None of the socials were available. It was an absolute punish. And if they had done their research up front, and they had, before they locked the name in, done a bit of digging and realised that there was, someone else who had that name in another market, then they probably would have avoided all those headaches. But, I mean, the websites are one thing. The thing about URLs is they're typically specific to locations. So in Australia, you've got a .com.au. In New Zealand, you've got .co.nz. In the US and Canada, you've got .com. And in the UK, you've got .co.uk or whatever it is. Whereas social media, you don't. Social media is like across the board. So, Matt Jones Plumbing in Australia, there could be Matt Jones Plumbing in America, the one in Canada, the one in the UK, and there's only one listing available for that name. So it's really important that you go and claim these things. Otherwise, exactly what you said happens. People go and do this work, and people think it's you. And I've got clients that just to this day have, like, marketing clients of ours who've got names similar to other companies, and they get these reviews, like negative reviews on Google, and they're like, "What? I've never worked for this person in my life," and Google doesn't give a shit. They're not going to take it down. But then we do a bit of research, contact the person, and it turns out that it wasn't even the same company, but because these companies got such a good presence online from all the marketing and stuff that we do with them, they just see it and go, "Oh, it must be them," and then bang, they just leave a review, and it's the wrong company.
Yep, absolutely. And often that's when you find out that this is happening. Remember I was saying that
Right.
It can happen for years. So, for example, that's one example of how a client of mine came to me with these Google reviews that had been left for shoddy workmanship. And that's when we did some due diligence and found that there was somebody else with basically their name as a Facebook page, and they were using the same branding and everything. I got them on the track of trademarking. So if you remember, we did that podcast a while ago on trademarking. So one of the sad things was that I had to say to this client, there's nothing I can do because you don't have a registered trademark. So we got them in particular to register their trademarks, a long process. But as soon as we've got through a certain milestone with it, once we've gone through the opposition period, we'll be able to then send a cease and desist letter and actually stop them. And then we can inform Facebook and everything that they need to take that page down, essentially.
Yeah, it's a really important step that I think 90% of businesses probably overlook when they're starting out, probably through ignorance, which is not their fault. They just don't know. But, like, it's really important, guys, that you register your trademarks for your business names. That's a rabbit warren, if there ever was one, going down that path with all of the different trademark categories and all this kind of stuff. But it's definitely worth doing, because especially, like, if you look at, even like plumbing companies, there are so many ridiculously similar names out there, and people competing, in direct competition with companies that have names that are like almost identical. For the life of me, I can't fathom how ASIC lets them register some of these names when they're so close to other ones.
Yeah, before I set up Rise Legal, I was trading as the contracts lawyer, and so I made sure that I got the business name The Contract lawyer and the contracts lawyer, and I got all those domain names and Facebook pages and everything because ASIC would have allowed somebody to register the contract lawyer. So, yeah, I mean, going back to what you were saying, when you're starting up in business, there's so many things to think about. You know, obviously I help people set up the company if they want a family trust and all that. But one of the things that I do address as part of my startup with them is all their intellectual property. And I'll actually say to them, you know, I'll say, what do you want to call your company? And they'll tell me, and while I'm on the phone, you know, I'm there typing away, and I'm looking, taken. And I also look at, you know, trademarks. I even Google it and say, did you realise there's somebody in Victoria that's got that? Oh, no, I didn't. I say, look, if you go away, you know, I'll give them a quick checklist. Yeah, I like my checklist. Here's a checklist. Go away and just make sure this, and this, because not only is it a case that you might be taking a name that, you know, is already in use insofar as, you know, it could be detrimental to you and your brand, but also you could be infringing on their brand. So you could spend all this money on, you know, websites and domains and business cards and wrapping for your vehicle. And then suddenly this letter arrives from a lawyer telling you you've got to stop doing it. It's costly. So do your due diligence before you even set up a name. But if you've already got a name, then, you know, like I said, definitely trademark it. And you can go back to that other podcast that I did about trademarking. I won't go into that.
Well, that was episode 246, how to make sure your business is ready for sale. Oh, no, it wasn't. It was 247, how to make sure your intellectual property is safe.
Yes, exactly. Yeah, no, that's a good one to have. But there's other things you can do as well. Obviously, as a contracts lawyer, I'm always, you know, talking about contracts, but there's a lot. You should have agreements in place basically with everybody that's surrounded you in a business sense. So everybody who's going to get confidential information or even get in contact with your clients or with your suppliers. So you should have, you know, for example, agreements in place, obviously with staff. I mean, that's a legal requirement, but we were talking on the last podcast about contractors. So if you've got people who are coming to you as subbies, even if it's on an ad hoc basis, you have to have an agreement that they sign. And that will have things like confidentiality provisions in. Provisions that protect your intellectual property. So, for example, if you do give them a shirt and say, you know, with your logo on or anything, that, you know, you're not giving them your brand, you're licensing it to them. So, but the biggest one is restraints of trade. So, obviously, as an employee, you expect to be restrained. So, by restrained, I mean there's restrictions on what you can do both during your employment and at the end of your employment. But also contractors, even though they're not employees, they should also have very, very similar restraints of trade on them.
Oh, that's interesting. So basically, if somebody's working for you as a contractor, you can have in their contract, they're not permitted to work for any direct clients in competition or something.
Absolutely. I mean, you can agree anything in a contract as long as it's legal, but that would be something that I would put in. You also want to avoid conflicts of interest. So, you know, anything that presents a conflict and they need to stop doing it. But with a restraint, what you'd want it to do is you want it to do a number of things, Matt. You'd want it to make sure that whilst they're working with you and for a reasonable period afterwards as well, that they can't actively compete with your business. That includes either entering into business arrangements or working for or providing services in any way to a competitor. And you've got to have quite a wide definition of
is that even through another principal contractors? Do you know what I mean? Like if they're subbing to you and they're subbing to another competitor?
Yeah, we can go quite wide with what you would want. So if somebody's been in a business relationship with you, providing your business with services, and you know that ends, you want to be very, very clear of what they can and can't do and in what capacity. What
about client obligations? So obviously, if I'm call a plumber out, you know, they come and replace a hot water heater or something, and then next time I want to get a plumber come out, I get a different plumber to come out and service the hot water heater. Is there like contractual things you can put in place in that regard to stop that happening? What you can do is have your client agreement, so your terms and conditions with the client, which basically say if you've got a third party to do X, Y, Z to the item we've installed, we will not be liable then for coming back under any of the warranties. So there's always ways to deal with it, but you definitely can't restrain somebody from using another business. But what you can do, like I was saying, was you can, if you've got people working with you either as employees or as contractors or as casuals, you can make sure that they've got these restraints of trade on them, which stop them actively competing with your business. Also stop them approaching or soliciting or dealing with any of your clients
either whom they had a direct contact with whilst they were working with you or for a reasonable period afterwards, so that they haven't come to work with you for the main purpose of gathering all the client details for their own business.
Would this be something that you'd build into, like you just when they contract to you for a certain job, you would in that contract it would have clauses which would dictate that. It would say you're not allowed to compete against, or you're not allowed to take our customers, you're not allowed to compete or contact our customers. Okay, yeah.
Yeah, absolutely. In any contract that I prepare for my clients, so we talked previously about the subcontractors agreements, that would have a restraint of trade clause in. I would deal with you and work out how you want it wording, because you're going to have certain ideas about it. But, I would make sure that's in there. That would also cover, so it's covering competition, it's covering soliciting clients. Also important things like not interfering with the relationship between you and any supplier. So it also, not in that scenario, I think that could have helped with your brother? Because if there'd been a contract in place with the guy who came on site, could we say that he was interfering in that relationship? And then also one of the other things I build into my restraint clauses is not actually soliciting any employees. So, you could have a really great team around you, and then you bring somebody in who starts having a little word and saying, I'm going to go out on my own. I see you're only on the award. I'm going to pay you more than award. And yeah, so all of those things are perfectly, when I say standard, I don't mean, again, templated. They're standard as in they're industry expected. If you enter into a business relationship with anybody else, whether it's employee, contractor, or even a joint venture, so, you've got two companies who decide to go together, so you might have one of them who does the solar panels and somebody else is doing maybe all the marketing for it, but you're on quite equal footing and you enter into a joint venture agreement. Those types of clauses would go in a joint venture agreement that I'd prepare as well.
And that's good. So, there's probably a lot of guys out there that are listening to this and or watching this, and they probably have some sort of contract in place when they bring someone on board, but perhaps they don't have that in it.
Yeah, obviously you can't add things to a contract, but you can, you can agree in writing to make a change and just have an annexure or something.
Yeah, sorry, get it added to your template. But that's a good point, actually. That is a good point. So how would you navigate that issue?
So if you've already got a signed contract in place with somebody and then you're listening to this podcast and you think it's got holes in it and I need to plug those holes. So if someone came to me in that scenario and I looked at the existing contract, I'd either recommend a new contract or I would recommend a variation, and you just do a quick variation, which needs to be, so any variation to a written contract needs to be in writing and it needs to be signed by the parties, and then it forms part of the contract as if it was always in there.
So that's a contract variation.
Yes. So either way, you've got to get a contract drawn up, and either way, you've got to get buy-in from the other side, and the other side has to sign it.
And that makes me think as well, like in terms of just contracts in general, is there, under your recommendation, a certain period of time where you should be revisiting them anyway and updating them?
Absolutely. I always do it as a new year legal audit. So I always say, because January traditionally for a lot of businesses is quite quiet. So I think January is a really great idea to actually dig out things and have a good look at them. Have a look at even things like, when's your trademark due to expire? When's your business name due to expire? And their contracts, make sure you've got signed contracts with everybody. Make sure the contracts contain all the clauses you need. And it's a good time to write to people and say, I've done my yearly audit of my commercial contracts. We now need to amend it to contain a clause that states this for this reason. We will be sending you a deed of variation.
Right. So it'd be a variation, not a new contract.
I think so, because just from a commercial perspective, if you were the subcontractor and you'd previously reviewed a 20-page contract, 15-page contract, maybe even sought legal advice on it, and then somebody presents you with a second 22-page contract, you might just go, whereas a deed of variation really is just a front page, the variation, and then the signature. So it's really simple.
What about for internally for, say, staff contracts and that kind of, I know you're not employment law, but still, is that something you'd revisit annually as well?
Yes, I would do. They obviously need to comply with the then current legislation, but I think with staff, what you'd be looking at more is their KPIs, the performance indicators, and seeing how people are tracking and whether you need to start, a performance management to get them back on track.
I suppose essentially what I'm asking is there a certain period in time where a contract that was issued is deemed null and void, like, oh, this contract was set out 20 years ago.
Yeah, well, there is laws on that, limitation periods, for example. So there's different limitation periods between agreements and deeds. So when you see something that's expressed to be signed as a deed, you actually get a longer period of enforcement for deeds. So, and, it all comes down to whether the parties are still working under that contract or whether, it's all fizzled away, etc.
So, it's probably not a bad idea to have some sort of annual January management checklist where you go through and you look at things like you just said, trademarks, employment contracts, supplier contracts, contractor contracts, just review all of that kind of stuff to see if there's things that are potentially missing out of it.
Absolutely. And this is where you find things like you don't actually have a signed one. And then that's when you go back through your email list and realise you sent Joe Bloggs the contract and that was 6 months ago and he hasn't signed it and returned it yet. So these are all, and often this comes out in the wash when you try and sell your business. If you remember the podcast on how to get your business ready for sale, you really do need to have written, signed contracts in place with everybody for a buyer. Otherwise, the buyer will spot it when they're coming to buy the business, and it suddenly becomes an issue that needn't have been an issue.
I can't stress enough how much easier that space has become with technology to the viewers out there. So many. All of our. We don't do anything in person. We haven't done ever, really. We've been completely paperless from the onset. But, contracts signed digitally, saved in cloud storage and all this kind of stuff. It's just so easy to do. And then, we never have that issue. We know things have been signed because the next step in the project management space can't happen until that's been checked. It just can't. You can't go ahead. So there are certain things you can do to completely mitigate those potential hazards.
Absolutely. Same in my world, Matt. I send out a costs agreement, which has got the agreed price. So I work on agreed fixed fees. I send that out and my workflow process is such that I can't do anything else until I've got that, at least until I've ticked the box to say that I've got the signed costs agreement back. And then that immediately takes you to the next stage. And I've programmed all that in. And I send mine through DocuSign. So it used to be obviously really hard for clients, to print out a PDF and then sign it and then scan it and return it. And I understand how hard that is. So we use DocuSign like most people. So it isn't hard. Once you've got these contracts in place, it isn't hard to get somebody to sign it. And if somebody can't press their thumb on their iPhone at night to sign it, then you go back to what we were talking about in the previous podcast about the gut feel. If they're not willing to sign or willing to press their thumb on their iPhone, then you've got a bit of a problem there.
No, exactly right. There's so many steps in our process when we're speaking to customers, which as much as a disqualifier as they are as a qualifier. And, we ask people to fill in a form on the website so we can understand what it is they're looking for. If they don't want to do that, and we have occasionally we'll get people come back and say, I don't want to fill a form in, I want to speak to someone. I'm going, well, we've already spoken, fill the form in so we can have a conversation, we're on the same page. And when people aren't willing to do that, perfect. That's great. I'm like, this is the perfect disqualifier. If you don't want to fill it in, don't fill it in. And we don't speak to them.
Yeah, perfect. Yeah, exactly.
I think a lot of people out there have that anxiety around, turning work away. And to be honest, I understand that. When you're starting out, you're kind of scratching and you will take anything you can get. So, that kind of mindset, I think, comes with experience. And as your business grows and you don't need everybody, you just need the handful, you kind of puts you in a bit more of a position of power and leverage there. But regardless, at the end of the day, you've still got to have some sort of screening process to be able to filter out the tire kickers or the duds, because they're the ones that will essentially suck up all your resources and be the biggest pain in your ass.
Exactly. Well, that's why it's so important to have a client agreement, because that basically tells the client, if you want to engage with us, this is how we will do it. This is how we operate. So if without actually saying the words, but if you don't want to operate in this manner, then we're not the right service provider for you, basically. So it doesn't go any further. We don't tick that box in our system because the client hasn't accepted our terms of engagement, and we don't proceed.
That could gain you a lot of respect as well.
Absolutely. I think you asked me in another podcast whether I would deal with tradies that don't have terms and conditions, and whilst I did do, because one was referred to me, everybody else I expect to see terms and conditions from them.
Oh, as providing a service, you mean?
As providing the service, yeah.
Yes,
So
yeah,
as
totally.
as a customer, it would definitely put a service provider in higher stead if they had a contract in place.
Yeah.
Forgive me?
Yeah. Well, I mean, because you were talking about the kitchen mob, weren't you, that did your place? Yeah.
Yeah, and they did a great job, and my house sold at auction, and I'm sure it's because of the kitchen. But, I was very lucky that they came on recommendation.
Right. And this is a testament as well. I mean, if they had heard this podcast maybe a year ago, they might have had those things in place, So you don't know what you don't know, but like you can learn things, guys. So it's important, I suppose, that as important as it is to listen to these podcasts, it's also probably even more important to act on them and, take a lesson out of this and actually go and apply something, because we don't do these for nothing. And I'm pretty sure I don't do them because you like the sound of my voice. Helen, are we done?
No, there's one more thing I wanted to talk about really quickly, Matt, and it's just confidentiality agreements. So often savvy tradies and trade business owners might think of an innovative solution to a problem perhaps, or recognise a gap in the market that other people haven't noticed. If that's the case, obviously don't go shouting from the high heavens about it in the early stages. Tell only those that you need to. So probably just the immediate family, and if you have to. But what you should do then is when you inevitably have to start getting other people involved, so inevitably you're going to have to speak to people about maybe manufacturing the product or distributing it or marketing it. Before you speak to any of those people, you need to give them a non-disclosure agreement.
I was just about to ask what NDA stands for.
Yeah. So, and non-disclosure agreement. So they're also called confidentiality deeds. Just it doesn't really matter what you call it, it's what's in it. And what's in it is some very good protective clauses, which basically say, this is my idea. I'm giving you this information for this purpose. So the purpose might be for the manufacturer of an X tool or for an app. Lots of people are coming up with loads of great app ideas. If that's the case, then the first thing you should do is go and see a lawyer and get a non-disclosure agreement drawn up for you for that particular purpose. And then before you speak to anybody about it, even an initial meeting, you should get that signed again. You could throw it through DocuSign, get them to sign it, and then you can pick up the phone to them and tell them about your app idea.
Because you read all these stories, and I've read loads of them in books of people going to pitches and stuff with NDAs, and people are like, get stuffed, I'm not signing that. Just tell us what your freaking thing is, Like, are they actually essentially in the books? I was saying these NDAs aren't worth the paper they're printed on.
They are definitely worth the paper they're printed on, because it's a legally binding contract. And if that contract says that we're giving you a confidential report for the purposes of you being able to quote us for certain services, and that report becomes public and you suffer commercial loss as a result of it, and it's directly attributable to that person having published it or given it to a third party, then a lawyer, a much cleverer lawyer than myself, a litigator, would be able to prove that chain of loss basically came from that breach of that contract. Without a contract, you have no legal obligation to protect somebody's confidentiality.
There's something that's off topic here, but I thought I'd ask you while I've got you in closing, and it's something that's happened to a friend and colleague of mine recently. He basically was absolutely slandered on national radio by a big radio station, who's quite well renowned for doing it. They basically lost a load of business overnight just from this guy going to town on them, and it was false. Like, they couldn't prove anything. Nothing had been proven. He just went out there and had this big resentment campaign against them based off some feedback he got from a caller and all this kind of stuff. Anyway, I'm curious in that situation because, like, obviously overnight they lost a ton of work. And I've had other guests on the show as well that similar thing happened. They ended up on a current affair, lost all this business overnight. None of it was justified. None of it was proven, but they don't care because they're trying to get sell a story. I was wondering in that regard, like, what can you do to protect that sort of thing? That's a fully loaded question, I appreciate, and it's totally off topic, but I know a lot of people like live in fear of that kind of stuff happening, especially as you grow.
Oh, look, if it's a third party and it's somebody, like a reporter, there's absolutely nothing you can do to stop it. But what you can do is make sure that you speak to an appropriate lawyer. If you feel as though the information was false, they could be able to bring a defamation claim.
Yeah, gotcha. Okay. Well, that's what happened. I think they even went up for a class action against them.
Perfect. So in the other scenario, if this had been an ex-employee or if it had been an ex-contractor of yours or a current contractor, then the contracts that I draw up have a non-derogation clause in, which means that you can't basically talk badly about the business. So if that was the scenario and it was somebody on a radio show saying, oh, I used to work for them and they don't treat the staff very well and they're not following procedure on site, we'd get them under the terms of the contract they'd signed.
Nice. That's a good takeaway. I'm glad I brought that one up. All right, great. Well, I think we've pretty much wrapped this one up. What do you think, Helen?
Talked about everything I wanted to talk about. I think the main takeaway is that contracts are your friend, basically. They can protect you in a number of scenarios that you probably wouldn't even think of. So if anybody wants to have a free chat with me, no obligation, obviously, I'll have a quick chat and I'll let you know if you've got any risks that I think you need to start thinking about addressing. Yeah,
and I'd recommend you guys do that. Helen's in the Facebook group too, guys. If you've got any questions, you can ping her in there. But I'll link to your calendar on the show notes. I think like we did in the previous episodes. Helen, thanks for your time, guys. If you've got any questions or you got any feedback about that topic of competitors stealing clients, if you had any experience with that in the past, I'm sure there'll be a few of you sitting there stewing on that topic. By all means, let us know how that played out for you. We'd love to hear it. Head across to the Facebook group on community there for the site shed and post a comment there, and we'd love to hear what happened and how you navigated that situation. Helen, thanks once again for your time. No doubt we'll be able to collaborate on something again in the future as questions pop up with the legal realm. I appreciate you taking time out of your day for this. Thank you.
That's okay. Thank you. And yeah, do keep putting comments in that Facebook group because that helps advisors like myself see what problems you're facing so that I can tailor content and tailor things like this to your actual problems.
Yeah, exactly. Most of these podcasts actually for the last couple of years now, guys, have come from comments that have come from within the community. So you guys fuel this content. Like I just don't go create off things I think you'd like to hear. I create off things that you tell me you want to hear. So get in there and get active and have a voice, and we will try and get your questions and problems resolved. All right. I guess that's a wrap.
Awesome. Thanks, Matt.
Thank you for listening to another episode of Toolbox Talks. If you're liking what you hear, then you can head across to thesiteshed.com where you can join our community by signing up to our Toolbox Talks. You'll get sent a weekly notification, which is basically a highlight of everything that we've spoken about during that week, along with any other industry news that may be relevant or specific to the trades. If you're enjoying the show, you can head across to iTunes, Stitcher, or SoundCloud where you can leave us a review. That would be fantastic, and all the reviews get read out in the show. Likewise, if you have any friends or colleagues that you think would benefit from the show and the episodes that we create, then please go ahead and share it with them.